Thank you for that mercifully brief introduction. And thank you all for inviting me to Wales for the first time. I trust we are safe and secure in this room from the scourge of seagulls that I just heard about on BBC Wales. I'm told that we have to put our hand on top of our sandwich if we don't want the gulls to carry it away. It's a privilege to be able to come here and reflect on what have been an extraordinary 2 years for those of us working on these issues. I think one of the things that we hear in some quarters is that for all of the drama of the Snowden revelations, nothing or not much has really changed. And while this reflects the good faith view of some people in the reform community, I think we hear it more often from defenders of the status quo. Just this week, former NSA and CIA Director Michael Hayden essentially mocked Snowden and the reform community, saying, if you had told me 2 years ago that all we would have is this minor legislative reform in the US, I would have said, that's cool, that's great. This whole exercise has been a waste. And I think that we need to understand that as an effort on their part, a real propaganda effort, to persuade the public that Snowden's act of conscience was in vain, an attempt to deter others from doing this and to demoralize the reform community that has the intelligence community in its sights. And I'm here to say that at least from a US perspective, and I think that we're going to hear more later on about the UK perspective, that's quite wrong. And I'm going to proceed this morning with 4 snapshots that will demonstrate ways in which the security state has lost power, lost authority, and the public has gained power and gained voice. And I'm going to be looking specifically at the courts and judicial review of surveillance and intelligence programs, and then at the Congress and the US legislatures, next at the technology community, and finally we are at a journalism school at the media. My first snapshot is from March of 2013. And this was a few months before any of us learned Edward Snowden's name. And the United States Supreme Court, in a case called Amnesty International versus Clapper that my organization, the ACLU, brought, held in a 5-4 decision that journalists, human rights workers, lawyers who were challenging the legality and constitutionality of an NSA surveillance program had no legal standing to be in court. They had no legal standing because the 5-4 majority said that our claim that these surveillance programs affected us was mere speculation, that it was based on a chain of inferences, and it wasn't enough to create a real controversy for the court to decide. But we could not get the evidence that we needed to establish legal standing because that evidence was a state secret. And so we were confronted with a kind of catch-22, the result of which was that neither we nor any other plaintiffs in an American court could actually get the courts to fulfill their constitutional obligation of saying what the law was. This case was dismissed without any adjudication of the factual or legal validity of the claims. And this really was a pattern, at least in the United States, of how the security state evaded judicial scrutiny. I spent many years trying to bring the claims of torture victims, rendition victims, into US courts, and every single one of those was also dismissed without any real adjudication on grounds of standing or secrecy or immunity. This perhaps will be a joke just for lawyers in the room, but I used to say that it was going to say on my tombstone, he died without reaching the merits. Meaning that every one of these cases was dismissed and thrown out by the courts without the court even answering the question, did these allegations happen, and was this conduct legal or illegal? Fast forward to July of 2013. Now in June, the very first published Snowden document was an order from the US Foreign Intelligence Surveillance Court to a company called Verizon Business Records, ordering that company to disclose on a daily basis all of the metadata from all of its customers' phone calls to be stored by the NSA for 5 years. And it took about 15 minutes within my organization, the ACLU, to realize that we were customers of Verizon Business Records, and that this document was our ticket to federal court. And in July of 2013, when I had my first conversation with Edward Snowden, when he was at that time stranded in the quarantine room of Sheremetyevo Airport in Moscow, one of his very first questions for me was, do you have standing now? He had been watching these cases very closely. And that decision, Amnesty versus Clapper, that I described, was one of his tipping points, where he realized that the human rights community, without evidence, couldn't get courts to actually decide whether these programs were illegal at all. Last month, in a case called ACLU v. Clapper, which we filed within 7 days of Snowden's first revelation, the first federal appellate court in the United States to consider the legality of that NSA phone tracking program unanimously held that it was illegal and had been illegal from the beginning. And this is something that would have been impossible, unfathomable, without Snowden's active conscience. And I think that it's significant for a number of reasons. Remember that this activity that the NSA was engaged in had been approved repeatedly by a secret court, the Foreign Intelligence Surveillance Court, that hears only from the government. And yet the first open appellate court to look at the very same questions came out with a dramatically different decision, much stronger, very, very well reasoned. And I think that the significance here is that it brings the courts fundamentally back into this conversation and into the role that they belong in. Second snapshot, and this is something that played on a loop in the US media and probably was seen many times here as well. And this was a hearing before the Senate Intelligence Committee in the US Congress, where a senator named Ron Wyden directly and bluntly asked the Director of National Intelligence, James Clapper, who you just heard about as a defendant in our other cases, is there any kind of information that the NSA is collecting on millions of Americans? And the answer was, no, sir. And Wyden was a little bit stunned by that answer. He said, no. And then Clapper gave the immortal line, not wittingly. A more accurate response would have been, yes. This exchange is routinely described as Clapper lying to Congress, but that's not really quite right, is it? Because the people in Congress who were asking the question knew the answer. The only people who didn't know the answer were the rest of us. This was a lie to the public. And it needs to be understood not just as a failure of the intelligence community to tell the truth, but as a failure of Congress to do meaningful oversight. And it's a perfect picture of the helplessness of Congress, that even people in our Congress who were against the surveillance programs, who wanted the public to do more, believe that they were helpless, that they couldn't actually educate the public. That same senator gave a number of speeches where he stood on the Senate floor and said, if the American people knew how the NSA was interpreting the Patriot Act, they would be shocked, they would be horrified, they'd be appalled. Now that turned out to be true, but we only know that because of Edward Snowden, not because of those senators who were constrained by their role from being able to actually educate the public. And this points to what is really a structural problem in legislative oversight over the intelligence community. First of all, the people on these committees only know what the executive branch chooses to tell them. And we find time and again that critical information is actually withheld from them. But another tactic that has been very, very effective for the intelligence community is fear. And this is not fear of the sort of traditional blackmail that we've heard about from decades ago, where the FBI director, J. Edgar Hoover, who held that position for half a century, had enough information on every member of Congress that they were worried about being personally exposed. This is a more subtle kind of blackmail where members of the intelligence community say to members of Congress, do you want to be the one to deny us this authority if there's another terrorist attack? We are going to be pointing the finger at you if there is another terrorist attack. And this is something that I hear very often when I speak to members of Congress, that it's extremely difficult to vote against the intelligence community on these issues. Because even if there's no merit to the claim, they do feel like they will take the political heat if anything goes wrong. They are also seduced by the intelligence community. There was a remarkable article in Foreign Policy magazine about Keith Alexander, the longtime head of the NSA, who brought in Hollywood set designers to design what he called his Information Dominance Center, which was modeled after the deck on the Starship Enterprise, with doors that went whoosh when they opened and closed. And members of Congress could come in and sit in the captain's chair and see all the incredible tools that were being made, and then sign on the dotted line for the budgets and the authorities that the NSA wanted. So let's contrast that to what's just happened in recent weeks. Some of you may have followed this debate. The Patriot Act, which was passed just after the 9/11 attacks in 2001, has provisions that sunset, that expire, unless they're reauthorized. And one of those provisions was Section 215, this phone tracking provision. It was set to expire on the 1st of June. It had been routinely reauthorized every time before then. And we saw the same old fear-mongering playbook being brought out by the administration and the security state. If you allow this law to expire, there will be mayhem, terrorist attacks, and a bipartisan coalition in Congress of liberal Democrats on the left and libertarian Republicans on the right essentially stood up to this, didn't buy it, and called the bluff of the intelligence community, allowed the law to expire, and then a few days later passed something called the USA Freedom Act, which is certainly incomplete as a legislative response to the scope of the problem that we're facing, and nonetheless historic, because it's the first time since 1978 that the United States Congress has restricted rather than expanded the surveillance authority of the intelligence community. So a third snapshot. In October of last year, the FBI director, James Comey, who is America's top law enforcement officer, delivered a speech at the Brookings Institution, which is a prominent Washington think tank. And the subject of this speech is what the FBI refers to as going dark. And what he's talking about, of course, is encryption. In the formulation of law enforcement in the security state, encryption is a problem to be solved, not a critical tool for freedom and security. But the worry is that because of the increased use of encryption, there are conversations taking place that even with a lawful order, the FBI and its partner agencies will not be able to get. Comey singled out Apple and Google, two of the world's most profitable companies, for moving to encryption by default on their new operating systems, meaning that in Comey's words, the companies themselves won't be able to unlock phones, laptops, and tablets to reveal photos, documents, email, and recordings stored within. Your prime minister, for those of you who live here, was perhaps even more blunt and colorful. James Ball has written about this. He said, "The question remains, are we going to allow a means of communications where it simply is not possible to listen?" My answer to that question is no, we must not. Now, compare this picture of the FBI director, of the British Prime Minister attacking these huge, powerful corporations to the image that we had from June of 2013 when we first saw the PRISM slides and we saw the logos of all of these companies that we use on a daily basis in an NSA PowerPoint presentation. These companies had been enlisted as deputized agents of the NSA to help them carry out their mass surveillance programs. And now, for a variety of reasons, the technology community has never been more adverse to the security state. And of course, there's a number of reasons for this. These American technology companies have global businesses. To the extent that they're viewed as being the lackeys of the NSA, it's going to be very, very hard for them to sell their products and services worldwide. But I think there's something else going on as well. I think these companies were genuinely shocked by some of the disclosures. They learned that even as the US government was knocking on their front doors with court orders under programs like PRISM, it was breaking into their back doors to siphon off billions of customer communications. For example, a program called Muscular, which was exposed by the Washington Post, involved the NSA secretly breaking into the main communications links that connect Yahoo and Google data centers around the world. The NSA had identified a weak point where encryption was added and removed, and had succeeded in exploiting that weakness. Those companies have, of course, since closed those loopholes and strengthened their use of encryption. Bart Gellman, who wrote this story for the Washington Post, said that when he brought these slides to Google security engineers, they responded with a loud expletive. This was in the story. What was not in the story, I asked him later, what was the loud expletive? He said the first word was mother, and the second word was not. This is very funny, but I think it's also very serious. We should think about these power centers, these massive profitable technology companies, and these huge security agencies as independent power centers. It's good when they are adverse to each other. It is bad when they are in the dark working hand in glove. We are going to need allies, profitable corporations, even ones whose practices we deplore in other areas, to help us to stand up to the overreach of the security state. And no doubt down the road, we're going to need governments to help us stand up to the depredations of these corporations and their bad behavior against consumers. So to the extent that the Snowden disclosures have helped push these power centers into conflict, I think that is a positive development for liberty. One more snapshot, and then I hope that we'll have some time for questions. And this is from July of 2013, and this is a story that will be familiar to all of you. When the GCHQ descended into the lower floors of the Guardian newspaper and presided over the destruction of hard drives and memory chips that included copies of some of the Snowden documents. Now, this was justly and widely mocked. The GCHQ had been told by the Guardian leadership that the documents had been transferred to New York already, to the New York Times and to ProPublica and to the Guardian in the United States. It was a futile gesture. But I think that it is perhaps better understood as a kind of temper tantrum by the security state, reflecting its deep frustration and its need to break something. You're going to hear from James Ball about some of the structural problems with security journalism that were very much on display in the Sunday Times debacle over the last weekend. That is that a single anonymous quote from a government official can create a front page narrative, but that on the other side, you need huge amounts of documents and evidence in order to create a counter-narrative. But the bottom line is that the security state is very, very accustomed to getting its way. That almost all of the time, all it takes is for them to make a few statements without corroboration and to control and to dominate the narrative. And after Snowden, that playbook became much less effective, I think for two reasons. First of all, these officials had no idea what was coming next. So they couldn't just play their old game of barely admitting what was already disclosed and denying everything else, because they could be revealed to be liars again 2 or 4 or 6 days later. And in the beginning, I think some of the journalists were having fun trying to coax denials out of the security state and then sandbagging them with stories a few days later that showed that they were lying and further diminishing their credibility. And actually, I think you need to understand the 9-hour detention of Glenn Greenwald's partner, David Miranda, as part of that frustration as well. Surely the British government realized that it couldn't actually recover anything that had been lost, that no one would be traveling with the only copy of something. But what they hoped was that they might learn what had been taken, because they were so clueless about what was in the journalists' possession, or at least give them the ability to predict what was coming next. I think the second reason why that playbook isn't working is that, again, more journalists are calling their bluff. In 2004, the New York Times learned about a huge NSA warrantless surveillance program. And two reporters from the Times, James Risen and Eric Wischblau, were prepared to publish a long, well-sourced expose of that program. And when the Times called up the Bush administration for comment, the Times publisher and their editors were summoned to the White House to a meeting with President Bush and the whole national security team, where they were told in blunt terms that if they published this story, there would be blood on their hands, Americans would die, it would be a catastrophe for national security. And that worked. The New York Times did not publish the story when they had it. They did publish it 14 months later after Bush had been successfully reelected. And they published it then only because one of the authors, James Risen, was about to publish a book in which he would have revealed it for the first time. And the Times didn't want to be scooped by its own journalist. That story went on to win the Pulitzer Prize for both of those reporters, created an enormous, at that time, political scandal in the United States. All of the Times editors and publishers who were involved in the decision not to publish have said that they made a mistake. And so when these issues came up again in 2013, post-Snowden, you saw much less willingness for these reporters to back down in the face of those kinds of claims. And I think the performance of the media, certainly the media that has had access to the Snowden documents, has been largely excellent. Part of this also has to do with the structure that Snowden created, where he made sure that there was no, what he called, single point of failure. There could never be something that resided only with one journalist or one news organization, so that if that one were intimidated, the story could be suppressed. He made sure that there was some element of competition. And so The Guardian needed to worry about the Washington Post, which later needed to worry about the New York Times, or ProPublica, or Der Spiegel, or someone else. So I think that was smart. And for all the criticism of how aggressive Glenn Greenwald has been, I think some of the most aggressive reporting has been done by more established newspapers like the New York Times and the Washington Post and Der Spiegel. Some of the stories that have come in for some of the most criticism are not the ones that have been published by Greenwald, that have been published in other places. So I think that you can think about those 4 snapshots as representing 4 mechanisms of oversight: judicial oversight, legislative oversight, private sector oversight, and fourth estate media oversight. I think at least in the United States, it's inarguable that all 4 of them have been strengthened in the last 2 years. Now the irony here is that we're talking about how democratic oversight has been reinvigorated, but that it required a very dramatic act of law breaking in order to reinvigorate that oversight. And relevant here, also a very, very strong free press that was willing to defy the demands of governments. And maybe one closing snapshot. In May of this year, Alan Rushbridger, who is stepping down as the editor of The Guardian, traveled with Ewan McCaskill and Janine Gibson from The Guardian to Moscow to visit Snowden and essentially say thank you, goodbye, and farewell. And they brought with them a framed piece of The Guardian's computers that had been smashed in that episode for Snowden to hang on his wall in his apartment where it does hang, as a reminder of how far we've all come in the last 2 years and how far we still have to go. So thanks for listening, and I think we do we have 5 minutes for questions? Yeah? Or 3 or something? Thank you very much.